Make a real quick copy of that.
James Austin, and then Norma on his case, Scott's case. I don't have. Okay, I just have it. All right, thanks.
Do you have a copy of the motion? Judge, do you have a copy of the motion on Mr. Austin's case?
Let me see. Just give me a moment.
Okay, sorry.
To modify bond conditions.
Beg your pardon, Judge. Yes, Judge.
All right, State, have you seen the motion?
But he's aware of what it is. He knows what it says.
Okay. All right, court is calling NIMAC number 758035, State of Texas versus James Austin. Can I have parties announced for the record for the state?
Daniel Rosengard for the state.
For the
Charles
defense?
Bunt for Mr. Austin.
Okay, and are you Mr. Austin?
I'm James Austin.
And here it is injury to a child. That charge alone spikes courtroom tension. Now imagine the accused wants contact with the child who's allegedly the victim. You already know this isn't going to be simple.
All right, let's go off the record for a moment. So this case is an injury to a child, correct?
Right.
All right, and the children that he wishes to see are one of the children the alleged complainant?
Yes. And they're all present, and the state's had an opportunity to talk to them today.
All right, and is CPS involved or no?
No, Judge.
State, are you aware if CPS is involved? Did anyone check? Is there some documentation that CPS ever go out to the location? The reason why I'm asking these questions, because if CPS is involved, they will have certain conditions. Yes.
If I may, yes, there is a CPS case.
All right. So here's the thing, Mr. Austin, before you speak, because there's information that I need. I know you're saying that the CPS case, maybe it's closed or maybe there are no conditions that have been set. But what I've discovered in my previous lifetime working CPS cases, sometimes the clients think something has happened and it hasn't happened.
Judges won't touch bond modification motions until they know exactly what CPS has ordered. Why? Because CPS trumps courtroom optimism every time. This isn't about feelings, it's about facts. So
here's the problem with me entering any orders, and I'm not saying I'm going to grant your attorney's motion or not, but I need to know if there are CPS orders and what those conditions are. Yes.
Yes, ma'am, with all due respect.
Okay, don't ever do with all due respect, because then what follows, people
I wasn't aware of that.
Yeah, that's what people always say.
Trying to be nice about it.
No, I appreciate it.
Appreciate that.
Yeah.
Well, I spoke with the CPS lady, and my wife has suffered with mental health throughout the years. I believe in the sanctity of marriage, so I didn't divorce her. The children were released to my custody. She left the children for over 30 days.
Okay, so wait a minute. Let me stop you right there. All right. So I want everybody to be in a place of kindness, right? And to be in a place of kindness, you don't say you're only staying with somebody because you believe in the sanctity of marriage. And you don't put, for lack of better terms, their issues publicly before the court when it's not needed. This is what I need. What I need is somebody, if you know the caseworker's number or something that's going on, pick up the phone, call the caseworker, and guess what? The state and the defense can talk to the caseworker. They're going to ask for the name of the oldest child, and they will go in their system and they're going to look it up and they're going to see what the status of the case is.
Okay.
Either they're going to tell me, yes, we've closed the case and the children are supposed to be with you, or either they're going to say, you're not supposed to have contact.
That's all I was just trying. That's all. I never get into that.
So let's land the plane by having somebody call the CPS worker, and then I'll take up this matter. Okay.
Will they let me know, the CPS people, if it's okay?
Your attorney and the state are going to call the caseworker.
Notice the Bible moment. It's not just symbolic. The judge calls it out, reminding everyone that court decisions aren't swayed by props, only by evidence. Subtle flex, Your Honor.
We're back on the record on NIMAC number 758035, State versus James Thomas Austin. Can I have parties announced for the record?
Daniel Rosengard for the state.
Charles Bunt for Mr. Austin.
All right. So, and you're Mr. Austin?
Yes, James Austin.
All right. You can lower the Bible.
Look, I even covered it up.
All right. No. The reason why I say that is this. People will come before me and sometimes they bring Bibles. Sometimes the Bibles have not been opened. They're brand new. But I don't want anyone to assume or think that because somebody brings a Bible that it is in any way going to influence the court's ruling. I'm just here to listen to facts and listen to argument and make a decision. That is why I say that. All right. So you all had stepped back to speak with CPS worker?
Yes, Your Honor.
All right. So what are the results of that phone conversation?
So there is still technically an active case. The investigators are going to be closing it within the next month. As of right now, they have not set any conditions. They've also not spoken with Mr. Austin, but they've said the mother has been following everything, all their recommendations, but they do not have any conditions as of right now. And if for any findings or any of that, she did indicate she need to get back to me before giving a definitive answer. But yes.
All right. So this is what is slightly concerning. And this is just based on my experience from doing CPS work.
Risk CPS is about to close a case, but they haven't even spoken to the father yet. That's like filing a report without interviewing a key witness. Red flags flying.
So it sounds like that's probably a family-based service plan. Is that correct or no?
That was how I interpreted it.
All right. So it's a family-based service plan. And it sounds to me as though their conditions or non-conditions is she has the children. She is not allowing the children to be placed in danger. I don't take any of these facts as true. And so therefore, they're getting ready to close the case. What's concerning is they're getting ready to close the case and they're telling you they've had no contact with him or spoken to him. So I don't even know if they have factored in the closing of their case that he wants contact. So did anybody ask them about their concerns, or maybe they don't have concerns with him having contact?
So just from my understanding, they mentioned that I believe he does not. I'm not sure if he actually still lives in San Antonio, or if he's back and forth between somewhere else. So from my interpretation, that if he was not in the state or in a different state, those concerns didn't seem to be.
All right. So this is what I'm going to do with regards to your motion. I'm going to set this motion for a hearing. And if you all can have the CPS workers zoom in, usually they're good about zooming in, and these questions can be answered. Because I don't want to do something that causes confusion or violates orders or thoughts that they may have. So
While I have the complainant present, does the court want to address her while she's here to avoid?
her coming back? Sure.
If the court has any questions for her, she is present. If the court wanted to inquire, I'm not suggesting what the court should do, but
Okay.
if the court wanted to inquire, she is present today.
Well, we can go off the record. If she is present and she wants me to inquire again, this is from my experience in CPS cases. If CPS has an understanding about her allowing or not allowing contact, and that's the whole basis for them getting ready to close that family-based service case, and she comes to testify, I don't have any issues and I want him to, that may affect or impact the closure of that case. So with that being said, if she still wants to come forward, she can. But I mean, a family-based services case, depending on the actions of the parties, can quickly turn into a legal case.
Understood. Yeah.
So it's completely, do you want to talk to her, Mr. Bonk, and see,
I'll work that.
and let her know what the possible impact could be? All
I
right.
had a quick question. Is it okay?
Oh, you probably want to speak with her.
It's
Yes.
not like that. Is it okay?
Sure.
Yeah, I live in Florida, so
Okay.
the transmute out here is really, really tough with these places.
Mr. Bonk, you can appear by Zoom.
That's what I was going to.
Yes, just ask him.
Oh.
Yes,
Thank you. very
sure. You're welcome. All right, who's here on Umberto Lara? All right, and where is your client?
Present in the back of the courtroom. Would you like him to approach?
Yes.
Morning, then.
Good morning. Just 1 minute. Thank you for dressing appropriately for court. So we're here on a motion to modify bond conditions. State, are you ready to proceed on the motion?
Yeah.
All right, court is calling NIMAC number 749226, State of Texas versus Umberto Lira. Can I have parties announced for the record for the state? Defense?
Kim Gonzalez for defense.
Switch gears. New defendant, new drama. This guy's a mobile mechanic, and his freedom depends on proving he works. In cash, can someone say gray area?
And are you Mr. Lyra? All right, defense has filed a motion to modify defendant's condition of bond. And are you requesting tracking only?
We were requesting tracking only, Judge. He has not been allowed to work. The state is in agreement to allowing partial from 7 a.m. to 8 p.m. We were requesting tracking only, but if the court sees that, at this particular point in time, tracking from those hours is appropriate, then we're fine with that. We just need to give him an opportunity to get back to work and earning some money.
State?
That we are opposed to modifications pretty much only. We are in agreement to give them a little bit more time in student money defense.
All right. So, of course, I know what a mobile mechanic is, but if you want to call your client as a witness to explain why the hours that the state maybe is not, is only given him is not sufficient. Otherwise, it will be work for a specific time frame.
Judge, I'll call him briefly.
All right. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand. Make sure you keep your voice up because the court reporter has to hear and I have to hear. If you'll state your name for the record. I'm sorry, what? Thank you. You may proceed.
Mr. Little, will you please tell the court how you're employed?
Mobile mechanic
And can you tell the court a little bit about how you get your jobs?
by recommendations.
Okay. And so when people call you, are you available? Do you try to make yourself available to them all hours of the day, or do you have a set time schedule?
No, whenever they call, and sometimes they call me at night.
Okay. And so are you just at the mercy of whenever people call you for work? Now, you're asking to be available after 8 p.m. or to be placed on tracking only should you have people call for business. But if the judge is able to allow you to work from 7 to 8, is that still helpful for you to get business and be able to pay your bills? And also, you have a daughter in school that you have full custody of?
Yes.
Okay, and so you've been paying somebody to take her to school in the morning? Okay, so if you're allowed to travel from, before 7 a.m., let's say, you'll be able to take her to school yourself. That's all I have, Judge.
Any questions? All right. So I have a few questions if there are no objections. So with regards to your business, when someone calls you and you go out, how are you paid? So here's the issue the court is having. I would be fine with him tracking for his work outside of hours, but there needs to be some sort of documentation that he's actually at work. I know usually sometimes people will sell. I understand sometimes people pay cash, but then there's no verification that he's at work. So that's my issue.
I'm sure we could put together some sort of receipt, Judge, for hours billed or something like that if the court's requesting documentation while he's performing hours if he's out.
This is the justice system, balancing trust and verification. Judge says, you can work but your cash payments don't leave a paper trail. And without receipts, it's curfew time. Hard to argue with that logic.
All right. And state, with regards to him being on tracking only for employment, what is your concern?
My concern is that he deviates from his working from hours for his business to go elsewhere, or that may stumble upon it out and start it, new offense, or violate no comments. It's also taking into account the safety using time not to go first. Yes, I think.
All right. So the court would not be able to see documentation that verifies that you are actually working at a specific location, just doing a cash business, which I understand sometimes when businesses are brand new, they do cash, but there's no verification. If there were some other